I'm David Lee from DeLuca. I'm an IP attorney, and been in the field for about 20 years, a little bit over 20 years, and represented a number of different types of clients, from startups to universities, healthcare entities, S&P 500 companies, and multinational companies. And throughout that entire time, startups come up in the conversation in some way, whether it's a client who is a startup or companies spitting out healthcare entities looking to license or acquire startups, or companies looking to acquire startups. The conversation about startups comes up in some way. And with startups, the question of intellectual property also comes up. So what I'd like to do today is talk a little bit about intellectual property essentials related to startups. And this is relevant not just to startups, but also to companies of all sizes who may deal with startups at some point. All right, so 3 things today. How important is intellectual property? I'll then briefly go over some types of intellectual property, and then end with a little bit about IP in healthcare. How important is IP? So I always like to start out with this question. We know Congress has the power to declare war and coin money. How many folks think that the power of government to regulate and promote IP ranks up there with coining money and declaring war? Okay, a few hands. That's more than usual. The framers thought that promoting the progress of science and useful arts was important enough to put in the same clause of Article 1 of the Constitution with declaring war and coining money. So the framers thought it was important. They're not around anymore, so let's look to today. How important is IP today? First of all, there's 4 different types of basic IP: patents, trademarks, copyrights, and trade secrets. I'll go over each of these in a little bit. I'm sure everyone's familiar with some of the examples here. So importance of IP today. Here is a graph of US GDP from 1963 to 2020. And here is another graph of US patent application filings during that same time period. This next graph shows that GDP and US patent filings are very correlated, with a correlation coefficient of about 1, which is basically as correlated as it gets. Now, what this tells me is that if GDP is a reflection of commercial decisions by companies, and US patent filings has a 1-to-1 correlation with that, it means that companies in their commercial decisions are talking about IP. And therefore, IP is in a conversation when companies make commercial decisions. It's important commercially. All right, so now, what are the different types of IP, and how should startups think about them? As I mentioned, four basic types: patents, trademarks, copyrights, and trade secrets. Patents cover inventions, and mainly inventions by people. So you need people to create inventions, and the law gives ownership of inventions originally to the people who invented them. Throughout this discussion about IP, one of the most important things to keep in mind is ownership. Whether you're a startup or a company looking to acquire a startup, think about ownership. Who owns the IP? As a startup, you want to make sure that your company owns the IP. As a company potentially looking to acquire a startup, you want to make sure the startup owns the IP, so that after the acquisition, there's no surprises from someone else who might claim rights to it. So in patents, it's important to correctly identify inventors and correctly identify all inventors. This does not mean list everybody on your team. This means consult a lawyer about who qualifies for the legal definition of an inventor. And the legal definition is anyone who contributed to conceiving of the invention, not folks who simply implemented an invention, but folks who conceived of it. So identify the correct inventors. I had a client once who tried to name their whole team of 27 people on a patent application, and that is not the right way to do it. After talking to them, we eventually narrowed it down to 7 people. And that is one of the things I see way too often, which is naming too many people as inventors. Ownership of inventions is transferred from the inventors to the company only by a written assignment, which is a legal document that transfers ownership. And so make sure as a startup, you have documents, legal agreements that transfer ownership of inventions from inventors to your company. Patent rights are also rights that are country by country rights. So be aware of that and make sure that your agreements transferring ownership of patents also covers the entire world. Okay, let's jump to trademarks. Everyone knows about trademarks or service marks. Basically, you think of a logo, and any of the ones that the presenters before have had next to their name, those are trademarks. Trademarks identify the source of a product or service so that when you see it, you immediately think of which company is providing the product or service. Trademarks and service marks provide protection for market recognition. If the market recognizes a logo or a word as being associated with a company, you want to, as the owner of that trademark or service mark, benefit from that market recognition without others benefiting from it who might try to use similar logos or words to confuse the public about who's providing the products or services. There are 2 types of trademarks. One is federal and one is state level. Federal trademarks are examined by the U.S. Patent and Trademark Office, that's the USPTO. And with respect to trademarks, rights in a trademark originally vest in the person or entity that uses the mark and not the one who created it. So this is a little bit different from patents. So imagine you work with a company who specializes in creating names for branding. A branding company they've hired. They come up with something that you think is a great idea, and you start using it. But maybe they have multiple clients, and before you start using it, they also make the same suggestion or similar suggestion to another client who then starts using it before you. Now, the company who uses the mark first is the one who gets the rights to it. So that's one thing to keep in mind. Just because you've hired somebody to create a brand for you, it's possible that someone else who uses it first can have the rights to it. It's not the person who creates it, it's the person who uses it first. We've all seen these marks before, behind logos, TM or R in the circle. This is the difference between state level rights and federal rights. The TM and the SM meaning service mark, TM meaning trademark, those are state level rights. The R designates a federal registration. And I'll go over what the difference is. So the state level rights are also called common law rights. They give rights in a geographic region to whoever uses a logo or a mark in commerce without registering it with the federal government. Now, this is great because you don't have to register a mark for you to have some type of protection. But the downside is the protection is only in the geographic region where the products or services are marketed. So let's say you're a startup and you start marketing in the New York area, your common law rights for that mark is going to be limited to the New York area. It's a little bit more fact-based than that, but that's the idea. Geographic area is the limitation for common law rights. And as I mentioned before, the danger with common law rights is that perhaps you've decided on a mark to use, but before you start using it, someone somewhere else could have started using it first, and they would then give the rights to it. Federal registration, on the other hand, is something that you apply for with the federal government, and it's not limited by region. It's presumed valid in the entire U.S., so that's one great benefit of a federal registration. Second benefit is that you can have something called an intent to use application, which is that even before you begin using a mark, you can secure your right to it. And that right is presumed valid in the entire US. So a lot of great benefits to a federal registration. And it gives the trademark owners the ability to expand geographically at their own pace without worrying about somebody else in another region using the same mark. Now, with respect to trademarks, as a startup, one thing you want to make sure is that you investigate marks or brands that you're looking to use before you actually use them. Because if you start using a brand and it gains market recognition, but someone else actually has used it before you, you may be forced at some point to either abandon your logo or your mark, or to not use it in certain regions of the country, which nobody wants to do. So for trademarks, make sure you look into a brand that you're going to use before you start using it to see if somebody else might already own it. Copyrights, these protect works of authorship, such as software code or web pages. Anything that a person creates that's original to them and they write it down, it is in the realm of copyrights. As with patents, copyrights originally are owned by authors, and rights to the work are transferred from the author to the company by a written document. So again, with patents, what startups should be aware of and keep in mind is make sure you have some sort of agreement or document that transfers rights from the author to your company. Trade secrets, the last type of IP, is really any information, business, financial, or technical, that you've kept confidential through some efforts, and it has value because it's not generally known. Think of Coca-Cola. Nobody really knows the formula, and that's what gives it its value. Now, trade secrets, it's not something that we see very much that startups use as an area of protection, but it potentially could be an alternative to patent protection. The reason we don't see it very much in healthcare startups is that there's often a need to disclose information to the public or to regulators to build credibility for your product and to build momentum for public adoption. So that need to disclose information for health startups is one reason that trade secrets doesn't come up very often as an option. But it is potentially an option to keep in mind. Okay, so those are different types of IP. Now, IP in healthcare. We're in an environment where in healthcare, there's limited access to healthcare providers, especially in rural areas. And providers are siloed that they generally don't have a full picture of patients' health history. At the same time, duration of visits are also fairly short. This is an environment where there are a lot of opportunities for startups to provide greater access, provide more utility for patients for in-home use through portable or personalized devices, and to provide medical devices that increase provider efficiency and patient outcomes. So the opportunities are there. Now, is there corresponding opportunities that are reflected in IP data? On the screen here, these are patent applications in the US in about a 50-year period for patent applications that are trying to capture and protect some sort of personal device or portable device or some sort of wearable in healthcare. What we see is from the 1970s to 1980s, there wasn't that much increase in patent applications in this area. We see a slightly more increase from 1989 to 1999, that one decade. And since then, a much more dramatic increase. So the opportunities are there, and that's reflected in the patent application filings accelerating in the last 2 decades. Now, in the same data, this breaks down how many of those patent application filings are by very large companies, about 500 million in market cap, and others. So the gray line is the portion of the total filed by very large companies with 500 million market cap or higher. And the orange line is everybody else. And what this means is that there is a role, there is a place for IP for startups. It's not just something that very large companies do. There is a place for IP for startups as well. So the takeaway is patent application filings are accelerating in this space, and there's plenty of room for startups. Thank you.